Right, I'm going to let them in now. Okay, good morning, everybody, and welcome to our Wednesday morning seminar. Today, the topic is I want my money, so getting paid. And leading this is Mohammed Haque, who is consultant barrister, adjudicator, and quantum expert. And he's going to be taking us through this morning. As always, if you have any questions, please feel free to use the Q&A or chat facility in the bottom toolbar there. Mohammed will happily answer these at the end of the presentation. Alternatively, if there is something that you would like to ask, but not in an open forum, you will see his email address there on the screen. Please feel free to make use of that and email him if you have a specific query. Okay, Mohammed, good morning and welcome, and the floor is yours.
Thanks, Shirley, and welcome everyone who's joining us in this morning session of the webinar, Wednesday morning session of the webinar. Julia has already explained that this is about payment of money under construction contracts, of course, although it doesn't say so, but it is about construction contracts. It says, I want my money and getting paid. Now, well, of course, there could be that you are a party who had met an accident in a construction project and you're looking for your money. And there is maybe contractual things or insurance or tort that will guide you how to claim the money and how to go to court if the proper amount is not paid. But today's topic is not that. Today's topic is all about contract. So although there are different types of payments possible, we're going to discuss about the payment entitlements of the employer, of the contractor, and this in a contract between a contractor and the subcontractor, both the parties there. Now, I could say at the beginning, and which I tried to, and then somehow lost it, is the payments under the contracts will only be either from the express terms. In other words, if you are looking for a payment, or you're saying, I want my money, it presupposes that there is a term of the contract which is stating that you're entitled to that payment. So the first thing to establish is, of course, there is a contract, and a term of that contract is granting you the right to get some payment. So the payment terms are coming, although it's the issue is different types of payments, but payment entitlements are coming either from the express or the implied terms of the contract, presupposing that there is a contract. So there has to be a contract, and you've got to look at the contract to find out what are your entitlements. A large part of my discussion will be focusing on the express terms of the contract, but because we're in the UK, and the UK has a heavy statutory regime regulating business contracts, not contracts which is for the residential occupation of the employer. So there's a heavy statutory regime, extensive one, which deals with the payment issues, all types of payments. And also then we have late payment of commercial debts Act 1990. I'm sorry, the year is missed here, 1998, which grants entitlement to interest payment. So all these types of payments are statute based. So I thought, okay, I will, in the first slide, I will say that that's by looking at the documents or the content of the express terms of the contract, you may not find all your entitlements. You have to keep in your mind that more often than not, you may have to consult the statutes. If, for example, if the contract is one which is verbal or oral, or partly oral, partly written, or evidenced in writing only partially, then you may have to, it doesn't necessarily have to be, but may have to. If it's totally oral, yes, there's no other place but to go to the statutes for your entitlements. Now, although the scope is limited, but at common law as well, there are implied terms which is relevant. For example, for interest payments, there may be, but you might think, but no. There may be installment payments or interim payments rights, no. So, but just because these two are no, that doesn't mean that there are other options or opportunities or prescribed implied terms, unless by express terms or by implication those are excluded. You may have a right granted by common law. For example, I've very recently done an adjudication as an adjudicator where the post-termination payment was an issue, and the first hurdle the claimant had to cross was where would you have your entitlement from, because your contract doesn't talk about it. And obviously they pleaded successfully that, well, it's common law that if you terminate a contract, in that case, I'm entitled to the accrued rights. And then if there isn't a date set or a procedure set for that right to get paid after termination, whatever entitlement that is, or even a recovery, then obviously again the statute will come into play. Because of time, I won't be able to discuss late payments that much in that much detail today, but I'll be focusing on the implied term under the statutes called the Housing Grants Construction and Regeneration Act 1996. I'll be referring to it as the Act, and of course there is a regulation made under it, and I won't bother to read out the full name of the regulation here. I'm just going to call it by its nickname, popularly known in England, the scheme. So that's more or less the implied terms, and that these are mandatory terms overriding. No contracting party has any right to dispense with those or exclude those by any limiting or excluding clauses. It has to be followed, and if certain provisions are missed, then automatically the scheme's part 2 payment provisions come into play. However, it's not like wholly replacing the express terms. It's supplementing, as and when it contradicts the statute or it has a gap. I mean, with the word it, I mean your express terms of the contract, then the scheme will come into play and they will supplement. So your rights or procedures to get the money, if you want the money, if you can identify a right under the act of the scheme, then you have a remedy, if so to say. So that's why the implied term thing has come first, although it's customary to talk about express terms. Let's go to express terms. One of the things that under the implied terms, you'll see I haven't included the VAT payments. It's because regardless if it's a term or not a term, that's a statutory regime which has got its own independent sort of machinery. And here we are not VAT tribunals, nor am I a tax lawyer. So not to speak of, or not to get ourselves involved in that, whoever party, and it's been judicially suggested that the best thing is to seek a clarification from HMRC about all different types of construction industry scheme, or AIT or VAT and whatever it is through a tax practitioner to go and find out. And if it's regarding, I mean, I occasionally see, and it especially happens where you have a charity constructing something and they have an exemption, and it takes a little while to get the exemption, and meanwhile the charity deducts from the payments VAT. So a problem starts actually, but so it's more of a refund type scenario I've experienced. But whatever that is, I will touch on this because sometimes and mostly it's discussed into the express terms, but that's not going to be the focus today either. So the different types, again, under the express term, be it express or implied, you will find that payments are normally, we got to also remember in construction contract that it has different time slices. It's at one time it's signed, not that every time it happens like that, it happens in a different order as well, but I'm saying mostly, or ideally speaking, it's the first thing is the contract being agreed, even if not signed, contract agreed. So that's one kind of starting. But actually, the real duration is from the date you commence on site, and then the construction period for the scope agreed. And obviously, there will be quite likely, if it's a JCT type contract, some switch for which the parties couldn't agree finally, or the sums were agreed, but the parties were not sure whether to go for it or not. So in situations like that, we may have something akin to provisional sum, or a provisional sum if it's a JCT, or nothing if it's an NEC and at a compensation event. The main implication are two types. One is payment implication, and of course, I will take a second to explain the other implication. That is, there is an issue of extension of time as well, because if it's a provisional sum, then the default position is no time has been provided within the calculation of the duration of the program. So, so if there are provisional sums within the contract sum, and if during the tenure of the period of contract, the employer decides to execute or ask you to instruct you through the architect, the contract administrator, or project manager to perform that item of scope of works. In that case, you are entitled, and if they decide that no, we do not want that item of provisional sums item or within this work scope, then you are no more entitled to anything for that. So there is a payment entitlement or non-entitlement, so to say. So that's normally in the express terms of the contract. And then the express terms also deal with the issue of any advance or a payment on mobilization, if there is any, and of course bid bonds and things like that, and then any interim stage or installment payments, and of course the final payments, and throughout. They tend to deal with the adjusted contract sums, because there are changes quite frequently, including the provisional sums, which I've already discussed. And then if there are delays for employers' fault, or if it's a contractor, subcontractor dispute for the fault of the contractor, then the aggrieved party, if there is an extension of time or an acceleration been agreed, then some kind of loss and expense is also due. So and quite frequently, rather than ignoring it like early days, the model forms and the bespoke contracts, they try to limit the things that these are the loss and expenses you can claim. And of course, within the final payments, the retentions are dealt with. And sometimes, also delay and interest due to delay rather than damages are dealt with within the express terms. There's an issue of liquidated damages, quite common in construction contracts, that if there is a delay for which no extension time has been granted, the employer, I mind you, there isn't any right for the contractor for liquidated damages. There is only loss and expense for the contractor, or common law damage in the absence of any provision for that, and unliquidated damages for instance. But it's quite common that within an express term contract, liquidated damages are imposed on the contractor, or if it's a contractor subcontractor, the subcontractor, if there is a delay and no extension of time is agreed or granted. And then, of course, I've already mentioned this payment on termination. Termination is a very common thing. I've seen many bespoke forms which do not talk about it, but preferably if you are drafting a contract, you should specify. But the default position is there's a common law employer term in contracts that if you are terminating, any rights that has been accrued to the parties up to the point of termination is claimable. And obviously you can say that can be set off, there could be a set off or a deduction. That's also a common law implied term unless you have agreed expressly. But as I say, more and more time, we see that the express terms are covering them, be it model form or a bespoke contract. VAT, the only thing you need to look at the express terms of the contract, if there is an agreement which is changing the default position. So normally the payer collects the VAT from the payee, and the sums agreed, the default position is sums agreed as a contract sum is actually excluding any VAT, but the parties may agree that the sum is inclusive of VAT, and if that is the case, then that is the case. So I'm not a VAT practitioner, nor I'm asking, or nor I'm focusing or discussing anything about VAT, but I'm discussing the express terms, which may include an obligation for you from which, and that may be different from the popular idea that X is responsible under the contract to collect and Y is responsible to pay. It could be the other way around, because the parties have the freedom to agree that although the burden lies on somebody, some other party will be responsible to pay it. So I just didn't want to complicate slightly more by referring to payments under incorporated documents, but that's also a chance. So before I leave this slide and go to the next one, what I would like to tell you is be specific in your mind, and you don't have to be a lawyer, a senior lawyer, or a contract professional very senior to understand this in today's world. Go and Google it, payments under express terms of construction contracts, and make a list. And then as soon as, if you are a QS or a contract professional, as either when you are agreeing a contract, or you have just agreed a contract and then you're a post-contract sort of payment professional, that's where you come and play more for today's discussion. You just take stock of what different types of payments under the express terms are available there, and create a track sheet, first a master sheet, that these are the payments, these are the clauses, and always remember to cross-check that or create a payment master sheet of procedures laid down. And who, when, what type of questions. Like, I'm entitled to, under the express terms, to get some payment when, and what is the nature of the entitlement, who's going to pay me, what procedure is involved. So if you have a payment master tracker, and if you have a calendar on the day one after you've signed the contract, or even before when you are agreeing the contract, well, if you can't prepare that, you know who to go to. But then if you have it at the beginning, if you are involved in the project, your life will be much more easier. And if you're a quantity surveyor attending, if you're doing a CVR, it's a must, because if anybody is not familiar with CVR is the cost value report, meaning for any period, maybe a month or a quarter, you prepare a kind of a projection that this much you are going to construct and this much you are going to earn. So these are our outgoings. So this much we are going to earn as a profit, be it accrued or we have the cash in our hand. So that's a periodic document prepared to assist everyone, where do we stand and where are we type scenario. And that also leads you to take a decision whether you need to make a claim or not. So if you are doing that, this track sheet is your first thing to be prepared on, and to be dot on the time that this is what I need to do, and this is where I will perform my obligation to be entitled, because always it's an entitlement. So your life is not so easy. They will make complicated requirements. You know, there's X and Y must approve these. Z and A should get a document before you are entitled, and I will only decide your valuation entitlement if you do this or do that, or if you fail, I will not consider your entitlement for a particular period. All sorts of things will come into play, you know. So if you have a list first or a master sheet on one tab, I'm a QS, so I love spreadsheets like most other QS. So on the first tab, the summary, these are the payments. The next tab linked the payment number one, let's say a contra-sum payment, definition, the pattern in which you're going to be paid, which contract clause entitles you to do that, what procedure has been laid down for the entitlement, then the timing underneath and all these, and see towards the end a checklist that you are performing all these at the right time. So if you have that in your hand, and then calendar link it, and then maybe with Google Calendar and such date, management always a step ahead, a week or 10 days earlier, that this date is coming, so I need to do something. As soon as an instruction comes in, I need to do something, you know, about the valuation and getting the payment entitlement proper. So that sort of thing. I'm not going to miss in my monthly cycle a particular variation, even if partially done, you know. Make an application, edit. I will get back to that, but these are the things you got to exercise. This is the only reason you need to come to a discussion like this. Otherwise, you know, everybody vaguely knows what the payments are. I mean, I just felt like, because I work like that, I'm like a stupid person. I have a list on my hand, and I have a spreadsheet always. So whenever I go to a project, or even go to a dispute, or even I sit on a dispute as an adjudicator, I just try to find out what payment am I talking about? And is this the claim that this is under the express terms of the contract? If that is the case, then where is that term? And is there a linked term to that? And is there a procedure involved in it? And have all these been complied with? If it's been complied with, you're entitled to your money. But what happens without going through this type of patterned, organized manner? People just think, well, I've done my job, I need my money. It's not going to help. Well, it will help, of course, the professionals to go in and then create something, either legal entitlement or quantum-wise, and gain some money and cut your pocket. So Well, if that's the case, that's the case. But one of the aims of today's discussion is you go back and you take on board a procedure within your department or your system, which addresses these issues. Anyway, let's go to the next one. Statutory payment provisions. I've referred to the Act. It says that unlike common law, and well, I mean, unlike common law, but mostly the express terms of the contracts were providing for some kind of installment payments, stage payments. The unfortunate thing is in English law, payments timing is never an essence, meaning that it's not a condition. So even if it's written on the contract that somebody is entitled to an installment payment, if the employer or the contractor doesn't pay the contractor or the subcontractor, the only remedy is damages or interest payments. So very difficult, you know. So there isn't anything like specific performance that you can go and compel the other side, or you can refuse if you're the payee to perform any further, because damage is always historically an adequate remedy unless a serious clause is inserted within, and it's sometimes the contracting is competitive. So if it's a buyer's market for the time being, there's lack of work, the contractors have very little strength or ability to argue that no such a clause should be there. So to help it out, the Act came into force, and it prescribes that every single construction contract, unless it's a very short duration, Section 109 of the Act says that for every single construction contract, it must provide for installment, stage, or other periodic payments and final payments. The difference is between stage and other periodic, meaning that stage payment is, I'm sure most of you are very familiar with this, but because we are discussing, let's just mention that as well. Stage payment is like, if you have completed this bit, I will pay you that. That's stage. And periodic payment is every month on the first day of the first business day of the month or working day of the month. You'll be entitled to get paid for all the works you have done in the previous month. And the valuation would be cumulative. I'll come back to it again, but remember the valuation will be cumulative. So this is the difference between a stage and a periodic, but either it's a stage or a periodic, whatever it is, it's an installment payment, and it's interim as well, meaning that you cannot just say that after you complete everything, I will pay, okay? However, the freedom for the parties are that they will have the freedom to agree in whatever gap or in whatever number of installments they want their payment. The parties are absolutely free. Well, there is an outside chance of arguing that if there says that there'll be 2 installment payments only, or 1 installment payment only 50%, then it could be that that was not an adequate payment mechanism. That could be argued, but this is a business contract. So, you know, when it comes to, you just try to create a monthly or a fortnightly or a weekly cycle as it's helpful for you. Now, for any works of the contract, that's the case. The statute is telling us it's overriding. No one can exclude it. It doesn't matter how mighty and powerful the body or organization is, they have to follow it, unless the contract period is about 9 weeks or maybe 45 days, something like that. I mean, I will just leave it for the specific to go and read the statute for yourself, but suffice it to say here that there are, of course, short duration of contracts, which if you can establish that the contract itself says that the duration of the contract is only these many days, which is within the statutory prescribed limit, then this provision doesn't apply. Otherwise, that's the case, that every single construction contract the payer has to make installment payments as agreed. Now, the most important possibly is Section 110 of the Act. The most important provision of the Act possibly is, not only it's just like those Roman revolutions, that not only you got to pay, you got to declare first that this is the amount I'm going to pay. And that declaration must be within a notice. It's not like an informal notification. It's a formal requirement. And if your contract fails to provide for that, this is implied by the statute. It's mandatory. You cannot take it out. So every single payment, for example, if it is for an installment payment, if it is for repayment of retention, if it is for payment of retention by the contractor by way of deduction, if it is an interest payment, if it is a final payment, if it is a payment for some defects, although normally the payments are not made for defects, but if the parties so agree that rather than rectifying the defect, the contractor will pay a sum for different types of defects during the defect liability period, whatever the payment is, if it's a payment on termination, whatever the payment is, this requires first a notice, and that notice can be given by the payer and the payee, or anybody appointed and expressed as appointed within the contract. But a payment notification is required before the payment is made. And the other mandatory aspect of it is the time limit. Okay. The other mandatory aspect is that you got to specify within the notice that on which date you are thinking that the payment is due, and how much is due, and why that much is due. In other words, the basis of calculation of the sum. So these are the different things the payment notice must contain. And it's been judicially interpreted to mean that a payment notice would be such, or should be drafted in such a manner that will tell us, anybody stupid as I am, that this is the sum which I want to pay, ascertainable, not very vague. John, further to my email on the last Sunday, you'll be, now I confirm that you'll be entitled to the amount you have discussed. It's not going to do. You have to be very particular in your statement if you're issuing a payment notice, that on such and such date due, you're entitled to this much amount as per our valuation of the works up to today. Gross is this. We have paid you earlier that much, so this certificate will get a payment of that much, and the VAT will be deducted from your payment, and things like that. And this much retention is deducted from your payment. So the net amount entitled, net amount of entitlement is this, and we are adding VAT now to that. So you'll be getting this much amount on your bank account. And of course, just because the notice will be given normally after the due date, there could be before the due date, but after the due date, within 5 days. So there'll be a time period by which the notifier must pay. That time period, the final date of that time period is called the final date of payment. So the way the logic works, because the notice is paramount, that first you have a set of dates which are due dates. Within a particular days of that due date, the payer or the payee or a third party can stand up and say that this much is the entitlement, and the statute requires us when, how, why type of things to be included, and it's a notice. It's not informal communication, though it could be sent by email, but it's like a formal document, and anyone reading that document must be able to ascertain that what payment is due and against which due date. And of course, the notification is only a notification, so there has to be a period of time by which the payment needs to be made. And the last date of that period by which the payment must be made is the final date of payment for the payment cycle or the particular payment we're talking about. And that's nutshell, and that's a must. You cannot, no one can avoid it, you know, section 110 A, B, whatever way, but this is what is a must. And some people get very confused about it. I don't know why, because it's a very simple thing. It just prescribes that say first, pay later. People sometimes say that pay first, argue later, and then they get very confused about 110, 109. 109 is just guaranteeing that you're entitled to installment payments, and every installment is valuation is cumulative, and the net payment entitlement means by deducting whatever has been paid earlier. That's it. It's your freedom, the party's freedom to decide in what gap, in how many installments under the contract they will get their payments, and when and how. But they cannot avoid installment payments. Section 110 is telling us, say first, pay then, or pay later. You know, so it's just a catchphrase if you want. That's my creation. Say first, pay later. So first thing is first, that before even if you pay, you have to declare within certain days. Prescribed time limit is 5 days from the due date. You got to issue a notice if you are the payer, or even if you are the payee. I will get back to this point of payer payee later on in a slide. How industry always assume, and in many cases that's correct, but not every time. But if you're a payer and a payee, either one, as the contract express term says, you can set in a notice that this is my, not can, you have to set in a notice, as the express term says. Or you could be, say for instance, a funder is paying, actually. So it could be that the notification will come from the funder. It could be that a quantity surveying is issuing the notice with the contract quantity surveyor. It could be the contract administrator. So it not necessarily have to be by the employer or the contractor. It could be some third party, as mentioned within the express terms of the contract and agreed. The notice might come from that particular office or individual, but the rule is say first, pay later. And if the rule is say first, pay later, then of course, you got to provide for the number of days within which you are to pay. And the statute provides guideline about that. If you have failed to agree, you know, again, it's the freedom of the parties, how long they will wait or give the payer to pay the money and settle the bill. But of course, if it's unreasonably delayed under these circumstances, you may have an argument that the payment provision of the scheme comes into play. Or if it doesn't provide, then of course the scheme has supplementary provisions which will come into play. Now, continue to discuss, and this is about the scheme. I've just said that if the parties fail to address an issue expressly as per the statute within the contract, express terms of the contract or payment terms of the contract, then of course the position is that the scheme will come into aid, and that's again a term which you cannot exclude. So the default position is the parties are entitled to draw their payment terms complying the statutory provision of 109, 10, 11, 12, and all these. And if that's not there, or was inadequately defined, like the dates were not given, like the procedure was not set, anything, okay, be it the due date, final date of payment, within how many days a notification needs to, within the 5 days prescribed period, of course, the notification has to be there. All these, you know, if there is any failure to fill in the gaps, the supplementary provisions, the payment the scheme will, payment provision part 2 of the scheme will come into play. So it's as simple as that. As soon as you are reading the statute, reading the contract terms, and see, look, the statute says this for a payer's notice, I don't have anything like that, or payee notice for my retention payment. Now, what do? Nowhere it says that how the retention is going to be paid back, or how much retention is going to be withheld. So it's after the practical completion. Do I have a chance to go to the scheme? Yes, if it's absent or if it's inadequately discussed, then you can go to the scheme, and your entitlement is under any other payment. So if there is a change or a change and variation, valuation, or compensation event been agreed, when would that payment be due? If you don't have a clause in your contract which clearly specify, well, it comes under any other payment. So payment on termination, I've already discussed, it comes under any other payment. You know, very recently, as I said, I was involved in a dispute of quite a good amount of money on payment on termination, and they were the claiming party was on a payment adjudication, and silly, the responding party said, that we have terminated, so there wasn't any more due date or anything like a final payment. It's not a JCT contract which provided for a post-termination final account, and the contractual date for submitting an application was 7th of each month if that was a working or a business day, and they have submitted it on the 25th of a month, and from which we were not sure which payment it relates to, you know, the case laws. So it's not an application at all. But very easily, the claiming party representative explained to me that this is a post-termination payment claim. The contract admittedly has not been providing anything for it. So the scheme comes into play, and the scheme says that if it's a final payment, it could either be a final payment under the contract of the accrued rights. It could be termed as a final payment under the scheme, and then I am entitled to get the payment. I'm entitled to make an application from the 90th day onwards, and I have submitted it on the 91st day, because before the termination, there was a brief period where the contractor was not on site. So that was the reason it was terminated. So I was, this is why I have completed all my items 90 days early. On the 91st day, I did my application under the scheme, and the scheme timeline applies. So the due date was on that day. So within 5 days of the due date, he was under a responsibility to issue a payment notice, and or within 17 days or 15 days, the final date of payment comes. So before that, the notice of intention to pay less should have been given. None was given within that time period, so I'm entitled to my money. Job done. So only if you know your contract payment terms and the tracker is there, you will know. Otherwise, you won't. And if you know that, it becomes so much easier. You know, any payment under this scheme does not include VATs, and it doesn't, because it's not a payment of contract, it's a payment of statutory regime. And also, there is a case which says that if you agree to settle a payment, remember this, if you agree to settle a payment, don't forget to add a clause there that this will be treated as a payment, like a variation or an extra payment or whatever way, supplementary to your existing express terms. And can be applied for under the applications or should be taken into consideration as part of the evaluation by the employer. If you don't do it, your payment is not under the construction contract, it's under the settlement agreement, and the settlement agreement may not be, unless it's a collateral contract to the construction contract, may not be treated as a construction contract, and scheme may not be applicable. A bit more clarification, bullet points, notices. Why am I saying notices? Because, as you know, there are three types of notices, actually. The first is the paradigm case. 5 days after the due date, the payer or the payee or a third party is required, whoever is required under the express terms to issue a notice of payment, say first, has to stand up and tell everyone else that this much is the entitlement for the period, okay, or for the particular payment we are talking about. Now, if a payment notice has been issued, that's not the end of the world. As I said, there is a time slot within which the payment will be made, and before the final date comes in, the parties may agree, that's why I said prescribed period, to issue a pay less notice than the notified sum. So the notified sum must be paid, but if couldn't be paid, then that's the case. Now, if I had a question that if a payer hasn't issued a notification of payment or a payment notice explaining the notified sum, can the payee come forward with a statutory demand? The answer first depends on whether the contract requires the payee to issue a default notice and he has issued it validly. Okay, if the contract requires, I'm repeating this, the contract requires the payee, when the payer is required to issue a notified sum notice, a payment notice, and failed to do so, or issue one which was invalid, let's say it has to be always within 5 days, he issued it within 7 days because the contract says so wrongly, okay, in the 7th day after the due date, it's a nullity. Now, just because it's a nullity, there isn't a payment entitlement in the hand of the payee. If the contract provides for a default notice, then the payee must issue the default notice first, then his entitlements start coming, okay? Alternative is, it's not a right. If the contract allows, in wide number of cases, it does allow an application, and the payee has made an application in advance under the contract, okay, and that was valid application. In that case, the sum contained within the application will be treated as the default notice of the payee, where the payer actually defaulted to issue the payment notice, which was his obligation under the contract as agreed, okay? So if the requirement is that if the payer fails, the payee will issue a default notice, then the first thing the payee needs to do is to issue the default notice correctly. Then we got a notified sum. Alternatively, if there is a provision that the payee will issue a pay less notice, then, payee will issue an application in advance. Then if he has submitted the application validly, that sum, any sum contained within the application will be the notified sum. However, that's not the end of the world. The question was, what will happen if I have defaulted and the notified sum is been accrued? So do I have to pay under section 111? Yes, you have to, unless you have issued a notice of paying less than the notified sum. And that is also to be given that particular notice, it's popularly known as Payless Notice, must be given before the final date of payment and the prescribed number of dates, which is agreed by the contract. Okay, if that period is gone and you didn't pay, then whether a party can issue a statutory demand or not, I will get back to that point in a couple of slides later. So, who issues I've already discussed, and schemes will come into play if there is a fault in that. Now, you have discussed this as well. Date for each payment, due date and final date for payments, and parties are free to agree. And if a notified sum is not paid, then an aggrieved party may make a claim. That's where I want my money. Okay, where to make a claim? There could be, these are the possibilities, that it could be that the contract says you can go to a particular level of management to get that. It could be a statutory demand. What is a statutory demand? Something which is in vast majority of cases wrongly issued. There is a law which says that if there is a debt and that's not being paid, and that proves that the person who's not paying is unable to pay, either he doesn't have enough asset to pay it off or he doesn't have enough cash to pay it off, in that case, you can issue a statutory demand to liquidate that company and get your money or proportionate amount of the money with other creditors. And that's the first step towards that. And so that's called a statutory demand. Now, mind you, a statutory demand is only valid if somebody issues it with the proof that the party is not able to pay, either because he has less asset than liability, or he has cash flow or immediate problems. That's why he's unable to pay. Just because a payment has not been made, no one has the right to issue a statutory demand. The first thing on today's date to note that the amount is no more £750. It's 10,000, and it will continue to be 10,000 up to the March 2022. Then the government will revise. This is due to Brexit and the pandemic. The government has raised the bar. But the second more important thing is, if you receive a statutory demand, it doesn't, or if you want to consider issuing one, I never suggest, because it's a difficult thing to prove that there is an inability. And the simple presumption is that if there's a dispute about the payment sum, then it's not a question of inability, it's the payment dispute. So it's not so easy, just because it's a kind of a threat, and a number of lawyers, they think, I don't know why do they think, to use it as a tool. I'm not saying it's wrong. It can be a tool, and then sit into a negotiation and settle the matter over. But just because a statutory demand is issued, you don't have to break down unless the other party can show the inability. However, you cannot ignore it either. If a statutory demand is issued within the prescribed time limit of the law, you got to respond, and you got to refute it and send it back that, look, I'm not unable to pay, I am not willing to pay because there is a dispute about this payment. And as long as you do so, that's what helps you. You cannot sit tight and say, okay, no, it's not, he's not entitled, so I will not do anything. Okay, but do check the sum is no more 750, it's 10,000. If it's more than 10,000, what is the statement? Is that they're saying that you're unable to pay? If that's what they're saying, establish that you're able to pay, but you think genuinely with reasons that they're not entitled to that payment. Okay. CAP is a new thing, conflict avoidance process, and it's very cheap. Experts come through, RICS provides it, and just Google it, I would say, to find out what that is. Mediation and settlement is another option, discussing and thinking forward, coming to a solution. Adjudication, well, I've been giving talks at adjudication matters. And there is, I think, another one on 2nd of December. So no point discussing it at all here. You can go to Fletcher Day or earlier Sil Shemming's YouTube channel if you want to know anything about construction adjudication, its pros and cons. It could be arbitration, and there is a business arbitration scheme of the CIR, which is one issue. Arbitration, which is very cheap. I think about £5,000 is needed for the arbitrator. So party cost is not recoverable. Litigation, you got to go through a pre-action protocol. And if you send a pre-action protocol, the business court requires you to go through compulsory mediation effort as well. If you miss that, you'll not get a cost order. So that's that. And claim and forum shopping, meaning where to go. Find out what type of entitlement you're talking about. Is it a notified sum entitlement? And as soon as you ask it this question, is it a notified sum entitlement? The next thing comes in, where shall I find the notified sum? Of course, within the notice. If a payment notice has not been given, what do I need to do? If I'm a payee, I should issue a default notice, or if the contract permits an application, then does the contract allow me an application? And if yes, have I made a valid application? If not, just don't take a chance. Issue a default notice. Just because the contract requires, it says, the law says that another default notice cannot be asked for. What's the harm? Just to avoid any future confusion that the application was not valid, issue a valid default notice. And that's not going to give you everything, because the payer still will have the right to issue notice of paying less than the notified sum. If they're prompt, they can save their scheme. Right or wrong, it becomes a valuation dispute then. It could be a valuation dispute, and try to find out, what are you disputing about? Is this about the measured work, which is the price for which has already been agreed, or the rates are known and you have performed it? Is it about a change and a variation or a compensation event? Is this about a loss and expense? Is this about the liquidated recovery of liquidated damages? Is this about payments you are claiming because there were defects, either within the defect liability or post-defect? And is it about unliquidated damages due to some delay or defects? And that's all. Every one of the above slides, you need to have your own track sheet, as I said, right on the day one, and you will be able to track them at the time when it comes.
Okay, thank you very much for that, Mohammed. We did have a question. I know you've kind of covered it within the main body of your presentation, but just to clarify, someone had asked, how should we, as a main contractor, respond to a statutory demand if we receive one off the back of an invalid payment notice, or if it is not issued?
Yes, as I've discussed, if you have received a statutory demand, then your sole argument is you are quite able to pay, but you are not intending to pay because there is a dispute about the payment. However, the problem is that, just as I said, say first, pay later, it says pay first, argue later. Now, if you are within this slot of the time between your invalid payment notice and either there is a default notice been issued or there was a valid application which crystallizes this notifying sum, then before the final date of payment and within the prescribed period, you have the right to issue a pay less notice, or a notice of intention to pay less than the notified sum. If you have missed that date, you actually have very little. Now, one of the things you can do is start evaluation adjudication immediately if you are able to, because in that case, then there is a time match issue. The statutory demand wise, you may respond back that you have come to a wrong forum because you are able, but there is a dispute. And regarding the valuation, this is going on there. Of course, within the valuation dispute, the other side can come forward with the defense of you have to pay first. And in that case, you'll get like at least a contemporaneous decision if you start your adjudication, valuation adjudication first. But if you leave it, as I said, if you leave it after getting the statutory demand, you'll be in trouble. You have to respond back within statutory time limit that I'm able, but I'm not paying because I'm disputing it, with, of course, good reasons. Then it could be that they will withdraw the statutory demand, but there could always be a possibility that they will come through adjudication, and you have no answer. So be prompt. If you're not within the time slot of issuing a payless notice, be prompt to start a valuation adjudication.
Right. Okay. Thank you for that. Now is the opportunity. If you do have any more questions for Mohammed on this topic, please, as we said, pop them into the Q&A or chat facility in the bottom toolbar. And as we have said prior, if there is something specific you wish to ask but don't wish to ask it in an open forum, you can email him at mohammed.haque@fletcherday.co.uk. As you saw briefly on the screen there, we are back this evening with John Sharp, and he's talking about insurance and the JCT contract. That's at 6 o'clock tonight. And then our last one of the year, Mohammed, bringing up the rear for us, closing down the year of seminars. He has the last in his adjudication matters, which is claiming time and money in adjudication. And that is next Thursday, the 2nd of December, 6 p.m. Either of those, if you would like to log in, please email me seminars@fletcherday.co.uk and we will happily book you in for those. Okay, thank you very much, Mohammed, for your time as always. Thank you everyone for attending this morning. Have a great day, and we look forward to seeing you either tonight or next Thursday. Take care.
Thank you. Bye-bye.
Bye-bye.